going to apologize in advance. If you feel this is not appropriate question for this forum, we can talk afterwards. Because I know this is the Institute of American Values and not the Federalist Society. But I would, you are affiliated with a group of scholars who advocate originalist interpretations of the Constitution, is my understanding. Maybe I've got your background wrong, but that's my understanding. So, you know, we're talking about traditional values. A very strong traditional value is the originalist position, which says that these Supreme Court should not effectively amend the Constitution, that the Constitution should be left to its original meaning, and if people want to change the Constitution, there's an amendment process that should not be carried out by the courts. Now, I'm going to put this in a strong way, just for purposes of the people who have watched through this whole thing on the video, unless I'm censored out, which I wouldn't object to. In 1868, when the 14th Amendment was passed, if you had gone to any member of Congress, of the 39th Congress, or any member of any state legislature which ratified the 14th Amendment and said, this new amendment is going to protect the rights of the freedmen and will also legalize sodomy, you wouldn't have gotten a single vote in Congress or any state legislature that ratified it. How can you justify the Supreme Court effectively amending the Constitution to add, you know, homosexual conduct to the protections of the 14th Amendment when that couldn't possibly be part of the original meaning of the 14th Amendment?
Okay, with the usual preface that this book is not a book of constitutional theory or about originalism, I think that I would respond to that in a couple of ways. One is that originalism, as I understand it and as I believe it's developed in legal theory, is not a theory that asks us to determine what the expected future application of the given provision would be. It is the idea that we want to take the principle as originally understood and apply it and allow it to be applied in the future. A couple of examples of this. When the framers of the First Amendment said that the Congress shall make no law abridging the freedom of speech, they could never have imagined the application of that provision to films, to television, to radio, to the internet. And yet it is not in the least bit complicated, it seems to me, or controversial to claim that the First Amendment applies to these circumstances, because we take the principle and we apply it to change circumstances. To get closer to home on the 14th Amendment, I don't think a single ratifier of the 14th Amendment or any of the state ratifying conventions would have said that the provision they were enacting, whether it was the Equal Protection Clause or the Due Process Clause, required that children go to school together regardless of their race, or that states could not have laws banning miscegenation, which banned racial marriage. Certainly, even if you could have gotten some agreement about that, which would have been controversial, I don't think they would have agreed that the provision they were enacting had made unconstitutional prohibitions on women being lawyers, which were accepted widely at the time. We have applied the 14th Amendment in a way that is broader and allows for more adaptation than the original expected application that they would have agreed to. And I don't see why that principle should be any different for this issue. And then it seems to me that the challenge for us is to come up with what we think that principle is, such that it actually covers some cases and seems like a principle we can't apply. But I don't think it forecloses the possibility of learning about a group of people and of applying that principle to in ways that they could not have understood, and at the same time be faithful to what they were doing. Because they may have recognized in framing the Equal Protection Clause the way they did that they couldn't see all of the changes that would come in society, but that they did not want the government drawing arbitrary lines between classes of people. At the time, they wouldn't have seen that as involving homosexuals or women or interracial marriage or any number of things. But it's not controversial to say it now, or at least in my view, it should not be controversial to say it now. So let me bookend it by saying this is not a book about constitutional theory. And in fact, I want to emphasize for people that this is not a book about constitutional theory or doctrine. This is not a book for law professors. I want people to read it beyond that, and I hope that they can.